504 of the Rehabilitation Act of 1973, and it's underappreciated, and it's very useful for anybody with disabilities. We make use of it all the time in advocating for kids, and it's very helpful. People consider it as a sort of a poor relation of idea. You're much better off with an IEP and so on and so forth. Well, in some ways that's true, and in some ways it's not. School people many times will tell you, well, you really can't get much with a 504 plan and so on. And sometimes they say that because they're lying to you. And sometimes, probably not in this district, because they're actually putting me on here, talking about it, they just don't know. Actually, it is quite different from IDEA in that it is a civil rights law. It gives you rights.
Give me a second, please.
Just a second.
Se escucha muchita ruido. Es que alguien más está utilizando el sistema y tal vez por eso, díganme si entonces no funciona, tal vez lo podamos hacer así.
Sí se escucha, pero con interferencia, pero sí se alcanza a escuchar.
Sí se alcanza a escuchar.
Es lo que se interfiere la interferencia.
Súbanle tal vez el volumen.
Yo se lo subí
Todavía
todo.
tenemos el problema, entonces tal vez lo podamos hacer así, porque no somos un grupo tan grande. Bueno, ¿por qué no nos juntamos en una mesa? ¿Sí? ¿Les parece? Miren, en la mesa aquella y lo hacemos en el sistema. We're going to do it up because I think there's a lot of interest.
Okay, that's fine. Should we close the door? This is making a racket here. Okay, that should help. Okay. Okay, so Section 504 is related to the Civil Rights Act of 1964. It prohibits discrimination. It's very closely related to the Americans with Disabilities Act. In fact, the courts interpret them together and construe the regulations in the same way. So the retaliation definition, for example, for Section 504 is taken from the Americans with Disabilities Act regulations. It originates in the 14th Amendment. People are entitled to equal treatment. So if you have a disability, or if you're black, or you're Latino, or whatever it is, you're entitled to the same treatment as anybody else. And that comes from the 14th Amendment, which says that the states have to do that too, not just the federal government. It also proceeds from the Brown v. Topeka court decision in 1954 that separate education was not okay. It was inherently unequal. So you couldn't put black kids in certain schools. If you take that decision and you just replace the words Negro and Negroes in the decision with peoples with disabilities, it becomes real clear that the 14th Amendment says you can't just take a certain class of people and shunt them off somewhere or isolate them. And based on that reasoning, the courts in 1971 and 1972 began to find that when they were not educating people with disabilities properly, they were violating their rights under the 14th Amendment. So in 1973, Congress passed Section 504 in order to put that in the law. So Section 504 applies to anybody that gets federal money, in it, however, indirectly. So school districts all get federal money. Regional centers all get federal money. They do not remember that they are under Section 504, but if they violate it, you can hit them up under that. You don't have to necessarily go through the fair hearing process. If they violate Section 504, you can pursue it that way. 504 is enforced. Through administrative compliance. It is enforced by offices for civil rights in various federal agencies. People speak of the Office for Civil Rights, and they usually mean the one in the Education Department, whose office is in San Francisco. But Health and Human Services has an OCR, and they're looking for business. So they're a good place to go, and if you have a problem with a regional center, HHS is a very good OCR to go to, and we have the contact information for that. In particular, schools in particular have to have a grievance procedure, an internal grievance procedure with a degree of due process. That's provided for in Title 34 of the Code of Federal Regulations at Part 104.7. If it's a regional center or somebody like that, the HHS regulations have it at 84.7. They have to have a compliance officer and they have to have a grievance procedure. Also, unlike an IP, where you have 13 different ways to get in and you have to assess and are they qualified and whatever, under 504, you qualified if you have a disability that affects a major life activity, such as, this is not a limited list, such as learning, sleeping, various other bodily functions, whatever it is. It's very broad. And it also talks about not only do you have that disability, but are you regarded as having that disability? Are you treated like you have that disability even though you don't have it? In any of those cases, you have that, you are covered by Section 504. If you actually, so they can't say, well, you don't really qualify. You qualify. If you have a doctor's note saying that you have a peanut allergy or diabetes or general anxiety or whatever it is, you qualify. So, being a Civil Rights Act, and it's about access, Section 504, along with the ADA, are all about, do you get access to the program? So, if you have a wheelchair, is there a ramp that lets you roll into the building? If you have diabetes, is there some way to take care of you so that if you need your medicine during the day, you get it? If you have if you need nursing care in order to be able to get into the place, does the nurse actually get to be there? In fact, is it an appropriate program? I've used 504 successfully in the ADA to push back against truancy notices from the district. The district didn't like that my kid was not going to school, and he wasn't going to school because they didn't have an appropriate program for him, so they gave him a truancy notice to retaliate against us. So I pushed back saying, you haven't given him a proper placement. You haven't given him a place to go. He's not truant. You're not letting him in the program. So that pushed him away several times. So 504 will work for you when they try to retaliate against you in that kind of a way. In particular, the USDOE regulations give you child fine. That is to say, they have a duty to look around and see if people have disabilities. They're not supposed to just sort of pretend that they're not there. Just like under IDEA, they have a child fine responsibility. If they see that a kid looks like he has problems, they're supposed to offer to assess him. They have a free appropriate public education requirement, which is very broad. It's not about, oh, we'll make little accommodations here and little accommodations there. They are supposed to give you special education and related services that enable you to get the same access to the curriculum that non-disabled people have. So under 504 plan, if you need special ed just the way you do under IDEA, they owe it to you. You don't have to get it from IDEA. The districts will sometimes tell you that you do, but you don't. You can make them give it to you under 504. You need vision therapy, you need you have vestibular balance problems and you need something there, 504. Are you here? Okay, you're not here. That's okay. You look like you were here, but you know, I make mistakes. So that's a very important thing. They will try to say, well, all we owe you is little accommodations and everything. The fact is, if you need special education, 504 requires them to give it to you. 504 requires that they place you in the least restrictive environment. That's at 104.34. You need some help?
No.
Very important. 504 under 104.35 requires that they assess properly, that they assess using more than one instrument, and that they assess in all areas of disability. They can't just say, well, we think that there's no problem here. The teacher says, well, you know, it's okay. There's no difficulty. Yes, the kid has a disability, but the disability is not causing a problem. They can't rely on the opinion of the teacher. They're supposed to assess rigorously and in a way that lets you see what's really going on with the kid. Very similar to the IDEA requirement. Finally, 104.36 gives you the hearing rights under 504 that are similar in some ways to IDEA, but they're quite different too, because the district is responsible for putting on the hearing. The district has to find an impartial hearing officer. The district has to provide for the hearing and pay for it. And the district is also required to provide a review procedure. So after the hearing, if you don't like the hearing, you're supposed to have a review procedure. And all of this they're supposed to do. We're on our way to a 504 hearing in one district that wants to fight us about everything, scheduled for December 9th. They've already picked a hearing officer. Sometimes 504 is a much better kind of a hearing because the issues are a lot simpler. In this case, we're saying they haven't taught the kid how to read. He reads at grade 3.5 grade level, and here he is in high school. You have kept him out of the high school curriculum. You might as well have said that the kid with a wheelchair can't roll into the building. When the kid walks into high school, reads at the third grade level, he can't read. You're not doing anything about that, so you have excluded him from the curriculum. That's a 504 approach to the problem. It's a lot simpler than, well, what do the educational experts say, which is what you're stuck with IDEA. 504 does keep it simple that way. The other thing is the 504, along with the ADA, protect you against retaliation. And I want to read the definition of retaliation that I took off of an OCR finding letter in the case in North Carolina. Retaliation. To establish retaliation, OCR first determines whether the complainant engaged in a protected activity. Like you made a complaint, you said you're going to make a complaint, you handed out a flyer they didn't like, you talked to a politician, whatever it was. You engaged in a protected activity. The district had knowledge of the complainant having engaged in the activity. In other words, if you did something and they don't know you did it, that's not a problem. They can't be retaliating. If you did it, they know you did it, and then the district took adverse action against the complainant. Could be they slashed your tires, could just be they yelled at your kid, could be that they said, well, you can't talk to district people, you've got to talk to our lawyer. All of that kind of stuff is retaliation. There was some evidence of a causal connection between the adverse action and the protected activity. In other words, you can't say, well, they retaliated against me because a year ago I made a complaint, and well, today, my kid, they suspended my kid for throwing spitballs in class. That's not retaliation. But if you made a complaint and the next news you know, you get a truancy notice, that's retaliation. So, fortunately, school staff have protection here. And this is very important because under IDEA there is in fact no explicit rule against retaliation. And the protections in special education in California are kind of weak for teachers who want to actually notice that a kid needs help, that sort of thing. 504 and the ADA are very strong. We just had a case in 2009 where a SPED teacher by the name of Susan Barker got together with a bunch of other SPED teachers in Riverside County, complained about how they were treating the special ed kids. And when they didn't get anywhere, they made a compliance complaint